This is an FDCPA case brought against a debt buyer, LVNV Funding, and this is what is known as the undispute dispute. So this is where you let the debt collector know you dispute an account, and then you tell the debt collector you no longer dispute that account. And the debt collector does not remove the dispute notation, and so then you file suit under the FDCPA. There's kind of a Fair Credit Reporting Act version of this, but in this particular case, we're going to be looking at the FDCPA. So we have the defendant LVNV filing a motion to dismiss, and ultimately the judge grants this motion. So we're going to see this idea of disputing and undisputing, and then take somewhat of a deep dive on the concept of standing. Not the most exciting thing, but if you file a case directly in federal court, you really have to understand this concept and the different types of attacks that can be made and how you have to defend those. So my name is John Watts. I'm a consumer protection lawyer, and a big part of my practice is involving credit reports. We're suing credit bureaus, suing furnishers, suing debt collectors, and also suing debt collectors under the FDCPA, Fair Debt Collection Practices Act. So plaintiff takes out a Credit One bank loan, gets charged off, it's sold to LVNV, and the plaintiff begins disputing the account, saying it's not mine. And then in August of 21, the plaintiff, through the Credit Repair Lawyers of America, sent LVNV a letter saying they no longer dispute the account. And so they want the dispute comment to be removed. So let's stop right there. Why in the world would they want this? Well, the reason is for a lot of home loans, getting a mortgage, if you have an account that says disputed by consumer, you will not qualify. Doesn't matter what your credit score is. You just simply won't qualify. So you have to go in and remove those dispute notations in order to qualify for the loan. So LVNV continued to notify the credit reporting agencies of the plaintiff's dispute after that August 26th letter. So was that 3-4 months later? Plaintiff filed a single count lawsuit alleging defendant violated the FDCPA. And we have this E2A, which prohibits falsely representing the character, amount, or legal status of the debt. And so they said, hey, when you're reporting it as disputed, when it's really not disputed, you violate this section. And also E8, which prohibits knowingly reporting false credit information by failing to remove the dispute notation after being asked to do so. So the plaintiff says, look, I got two types of damages. These are the actual or compensatory damages. I have economic damages and emotional distress damages because of your violations. So 12B1 provides a dismissal of a complaint for lack of subject matter jurisdiction. So you lack subject matter jurisdiction when you do not have what's known as standing. So standing implicates a court's subject matter jurisdiction, must be addressed threshold issue. All right, what in the world does that mean? It just means that federal courts are courts of limited jurisdiction. So we have to show that we meet this concept, and it's a little murky at times, but this concept of standing if we want to file directly in federal court. Now, the way I do it, I file in state court. The defendant removes the case to federal court. Well, they have to prove standing because they're the ones that are asking to be let into federal court. I'm not doing that. But if you file the case directly in federal court, you bear that obligation. And if the other side says to the judge, hey, there's a problem with standing, which typically means that you can't prove a certain type of harm. All right, and we'll look at that in the case. And this is going to get a little detailed, okay? But it's important if you're filing these lawsuits to understand the concept of standing. There are two types of attacks that can be made. There's a facial attack or a factual challenge. These are completely different, okay? Now, the common thing is they say you don't have standing. But the facial attack says just look at the complaint. Has the plaintiff said enough in the lawsuit, in the complaint document, to satisfy standing? A factual attack says we don't care about the pleadings. We want proof. We want testimony. We want affidavits. And the trial court is to weigh that evidence and to decide whether or not it's been met. So these are radically different things. One is to say, I just look at your lawsuit and we're facially challenging that, which means you didn't plead enough. The other says, yeah, we don't care about your pleading, your lawsuit, your complaint. We want the proof. We want actual evidence submitted. So in short, when a party mounts a factual attack, district courts free to independently weigh the facts may proceed as it never could under 12b-6, which is when we're just looking at the complaint. This is what's typically called a motion to dismiss. Okay, so the defendant moves for dismissal under 12b-1. All right, so this is just a rule of civil procedure, lacks standing. Defendant raises factual challenge. I'll consider extrinsic evidence. So extrinsic would be outside of the complaint. So we're looking, as the judge said here, for testimony, exhibits, affidavits. In other words, actual evidence. So now we get into this Article 3 standing. So Article 3 of the Constitution limits federal jurisdiction to cases or controversies. And so from that, the courts have said, well, that means we have to have standing. And that is the power of the court to entertain the suit. And so there's really three things here. Number one, injury in fact, which is almost always the battleground. Number two, fairly traceable. So the thing the defendant did, that is what is causing my harm. And then number three, that you can remedy the situation. Okay, so I mean, when we're asking for money damages, that's easy. If we're asking that the court turn back the hands of time, well, they can't do that. All right, so here's an 11th Circuit case. People pronounce this differently. Trichel versus Midland. As a party invoking federal jurisdiction, the plaintiff bears the burden. Well, think about this. If we file in state court, the defendant removes it to federal court, they're the ones invoking, they bear the burden. And if they don't, it goes back to state court. So the focus in this case is on number one and number two, injury in fact and causation. So let's talk about this injury in fact. You have to show you suffered an invasion of a legally protected interest, concrete and particularized, and actual or imminent, not conjectural or hypothetical. It's a bunch of words, right? And it gets a little bit confusing as to what all this means because different judges have different viewpoints. So each subsidiary element of injury, legally protected interest, concrete, being particularized, imminence, must be satisfied. Plaintiff cannot establish constitutional standing based solely on a bare violation of a statute. So the fact that the defendant violated the FDCPA is not enough to give you standing. I think that's sort of ridiculous, but that's the way the law is right now. So rather, the consumer, the plaintiff, must show the violation caused him some real harm. In this context, very nearly any level of direct injury is sufficient. So here's an example from the 11th Circuit. With the 11th Circuit is a court over federal judges in Alabama, Georgia, Florida. So a concrete injury need be only an identifiable trifle. You love all these words? So allegations of FDCPA violations without more are insufficient because you got to have that trifle, right? Which sounds like something you eat after dinner. But anyway, that's what we say here. To demonstrate traceability, so remember that's element number two. Number one is we got to have that concrete harm. Number two is traceability. You have to show a causal connection between what? Between the acts of the defendant and the injury. We have to be able to tie those together. The defendant did something bad that resulted in an injury to me. We have to be able to show that. Traceability is less stringent than proximate cause. That's a concept we learned in law school. And so they're just saying that it's not a real tough standard here, okay? Therefore, an injury that is indirectly caused will satisfy this. Even so, if the injury is caused by a third party not before the court, it's not satisfied, and it's not satisfied where plaintiff independently causes his own injury. All right. So sort of stay with me on these headings here because it's easy to lose our place in these standing opinions. It's nothing the judge did, and that's why they give us this. So judge says, look, you lack Article 3 standing. Defendant argues plaintiff fails to prove any concrete injury caused or what was caused by the defendant's conduct. So that's those two elements. Plaintiff says, no, I got two concrete injuries, economic harm and emotional. So here's economic because he's not eligible for conventional mortgage financing or refinancing due to the failure to accurately report he no longer disputes the account. So he's unable to get those rates while they were at historic lows. And this causes him to be harmed. And it's very emotionally upsetting. Anxiety, embarrassment, etc. So the judge says, I agree with the defendant that you failed to establish injury in fact and traceability. So now we're still under this broad category of standing. And now he's going to look at economic injury and say, you don't have an injury in fact through economic injury. Remember, the plaintiff said 2 ways I have an injury, economic and emotional. So let's look here. Plaintiff has not established suffered economic injury in fact. He said he tried and was unable to provide or obtain mortgage, but he clarifies he never actually applied for a mortgage. Nobody ever turned him down. He said he and his wife attempted to apply, but the broker declined to submit their application to any lender until the dispute notation was removed. And the broker said no lender would approve them with that dispute notation. Now, we've seen other courts that say the fact that a broker says, I can't get you a loan because of this information, that's sufficient, but not for this particular court. Plaintiff fails, however, to offer any proof that he could not obtain the mortgage. So where's the affidavit from the broker? Where's the deposition? Where's the paperwork from the broker? Why he refused to proceed? Plaintiff does not even recall receiving any correspondence with the broker, speaking to the broker himself. He says, well, he spoke with my wife. And then they point out, well, your wife hadn't submitted an affidavit, was not deposed. So now we start to get a picture here. Maybe it's not just that you didn't apply for a loan, but you don't have any evidence of this. Okay, so let's keep reading and see if we can really try to understand what the judge is saying here. Neither the broker nor the wife are listed as witnesses for trial. Okay, and the only witnesses are the plaintiff and the corporate representative, neither of whom can testify to this unsubstantiated hearsay testimony. So remember, this is a factual attack, not a facial attack. Facial, you just look at the complaint, you say, hey, it harmed me, here's what it did, and that's enough. But a factual, we have to present facts. Here the defendant has brought a factual attack after discovery is complete and the parties are preparing for trial. Challenges the existence of subject matter jurisdiction regardless of the pleadings. Cannot rest on mere allegations but must offer competent proof. Must establish standing by affidavit, testimony, or other evidence of specific facts so a district court can weigh the evidence. All right, so even if plaintiff had proven that the broker declined to proceed, now we've got to do this causation or traceability. Okay, so number one is no injury. And the judge says you don't have an injury, economic injury. But then even if you did, you can't connect it. So let's see what the judge is saying here. He has not shown it was because of the dispute notation and not for other reasons. So plaintiff has not produced any evidence establishing the effect of a dispute notation on creditworthiness or obtaining a mortgage. And talks about, and there's a footnote here, he had all sorts of other loans. Plaintiff is not qualified to testify about the impact, offers no expert testimony, has not shown his economic injury, which the judge thinks he doesn't have. But even if he did, it's not traceable to the conduct. So therefore, there's no economic harm. So remember, we're looking at injury and traceability. And we're looking at 2 types of injuries, economic and emotional stress. Judge says you don't have any economic, and even if you did, you can't tie it to what the defendant did. So now we're going to look at emotional distress. 11th Circuit has not yet decided in published opinion whether emotional distress alone is sufficiently concrete injury for standing purposes. I would say actually they have, okay? And so the Loesch case, which we've talked about here before, and that was in a different statute, but it's the same concept here. All right, so in the FDCPA context, Fair Debt Collection Practices Act, courts in the Southern District are split. And this is important to understand this. Not every judge in the country agrees. Not every judge in a circuit, so a circuit like for us is Alabama, Georgia, Florida. Not every judge there agrees. Not even every judge in a state agree, and not every judge in a district. So this is the Southern District, just think Miami area. And they're saying, well, we are split on whether emotional harms arising from alleged violations establish standing. So here's Judge Ruiz. Let's see here. Concluded receipt of misleading letter without a claim of concrete downstream consequences is insufficient. All right. Judge Ruiz also found the court could not rely solely on his feelings of distress or confusion or anxiety. However, Judge Martinez said emotional stress damages are sufficient. Judge Martinez says, well, this is based on the 11th Circuit's determination. Actual damages include damages for emotional distress. Okay. And so this is in the Rivera case. And this judge says, I disagree with the reasoning in Rivera. Okay. Because of this trickle or this Trichelle, this Midland case, and articulate a critical difference between injury and statutory damages. I'm not sure I completely follow this, because what Judge Martinez says is if you have actual damages, that's enough. And now we're sort of switching to statutory damages, which is where you get up to $1,000 even if you're not harmed. Okay. And in any event, here's what the judge said. Congress viewed statutory damages not as independent font of standing without traditional, but as an additional remedy suffering actual damage. Again, I'm a little confused, because I think this is what Judge Rivera is saying here is you have to have actual damages, which emotional distress would be actual damages. But in any event, Article 3 does not exist simply because FDCPA provides for statutory damage. Again, I don't think that's what Judge Rivera or the judge in the Rivera case was saying. So I won't follow Rivera, which relied on damage categories, and Judge Ruiz is presiding judge in this case, so his decision will guide the outcome. With respect to emotional distress, there's just an allegation here, okay? And they say without more, that's not enough, okay? You can't rely only on feelings of distress. And I'll say this, it gets very detailed in the 11th Circuit. How do you prove emotional distress damages? There's a way to do that, even with your own client, certainly with other witnesses. And, this judge feels that it has not been met here. While generalized allegations may be enough at the pleading stage, that would be a facial challenge. They are insufficient once we're at a dispositive motion by summary judgment time. Courts up the ante to stay in the game. Now, here's where it's a little confused. This isn't really summary judgment, okay? This is a motion to dismiss, but because it's attacking factually, now the court considers evidence like it would in what's called a summary judgment. So again, it gets a little confusing, but the point is the judge in this case is saying, look, you got to have real evidence, okay? And, where are the people testifying to this? And so they say, this isn't enough here. All right. Plaintiff also fails to prove any distress he experiences traceable. That's that causation. So element number 2, to the actions. He may have been distressed, but he hasn't proved the dispute notation was a primary reason for the broker's decision. Now, he said the broker said, I can't do this because of the dispute, but there's no evidence of that. There's no testimony from the broker. There's no documentation from the broker. And instead, apparently, there were multiple issues with the credit. And so then we come down here and testified didn't recall anything else on his credit report. The judge says, well, I think there was, and you haven't submitted a copy of your credit report to show. And so that's not enough. Okay. I schedule an evidentiary hearing to give plaintiff ample opportunity to present evidence bearing on the existence of jurisdiction. No broker and expert appeared. Plaintiff's wife did not appear. No admissible evidence. Plaintiff responded that the court must accept as true all material allegations of the complaint. That's the standard for a facial attack and for a typical Rule 12 motion to dismiss. But the judge says plaintiff cites an incorrect legal standard. This is a factual challenge, so we have to submit facts here. And so it's recommended that it be dismissed without prejudice. My memory is that's what the district court judge did. So it just means you didn't lose on the merits because I, the federal judge, found out I don't even have any power to be considering this. And so it may be that the case was refiled in state court, which may have a different standard. So I don't know what happened with that. But again, the thing I want you to get from this case is that we have to understand those differences. And it is This is not an easy area because judges kind of use the same terminology in different ways. And frankly, there's a lot of contradictions. But you can kind of see at least what this particular judge feels like should be happening here. If it's a facial challenge, yeah, we just look at your complaint. If it's a factual challenge, you better have evidence. I mean, we need witnesses, affidavits, documentary evidence. You've got to kind of prove your case there. So hope you found this helpful, and I will catch you guys in the next video. Okay, have a good one. Bye-bye.